hasten the footsteps of those who are coming. Give us guidance. These are the mercies we ask in the most humble name. Amen.
Thank you, Member Scaffrey. Apologies for absence.
First, I want to apologize for lateness. Senator Scaffrey and I had a special difficulty that got us here late, so we apologize to the technical teams and to you and the other members of the committee.
Duly noted, Member Brown. Any other apologies?
Yes, Chair. Apology for Richard as urgent matter, illness. He's not ill, but
the other beaker. Yes, duly noted. Yes. Again, let me welcome you to this another Monday meeting of our Joint Select Committee on Occupational Safety and Health. Today we are set to continue our clause-by-clause analysis of the bill. Before us for this sitting is a document prepared by the Ministry of Labor dealing with Part 12 of the bill. Yes. Do we have members have copies? Where are the copies? All right, copies will be circulated shortly. Also, there is a reply from the Ministry of National Security in respect of a breakout that we had asked for. This comes by way of letter under the signature of the Permanent Secretary, Ms. Diane McIntosh, dated June 15th, 2020. Members, do we have sight of that document?
Opening that set of email, that and the one with the thing, so maybe there are
yes, copies will also be circulated. Just now I see a member from the PSOJ has finally turned up. They have sent a representative. Dr. Dayton Campbell from the PSOJ is with us. I welcome you, Dr. Campbell, to this.
Robinson.
Dr. Robinson, sorry, I don't know where I said Dayton Campbell. Well, thanks for the correction.
Thank you.
They're one of a kind, so do understand. So welcome, Dr. Robinson. Do feel free to participate. If there's any matter that you so desire to comment on, once you indicate with a show of hand or your name card, then you will be duly acknowledged and recognized.
Thank you for that, will do.
Yes. So members, any other housekeeping preliminary matters before we get into the business of the day? Have we all been served with copies of the documents? Part 12, I believe, today we are set to pick up at part 11, is that so? As we would have completed part 10 on the last occasion. Part 11 covers clauses 194 to 200 of the bill. It was issued last week. Part 11. Yes, you would have been served copies of, yes. Well, we completed a section on improvement notice, and we were now to move on to enforceable undertaking. which is covered in clauses 194 to 200.
Just before I get there, Chair, if we could just revert to the housekeeping issues. Have we heard from the Confederation of Trade Unions that I believe they had agreed, and I'm not sure if they had named their rep, because in other communication I got the sense that there'll be a rep present here today. So it will be good to know if that is so.
Yes, yes.
I spoke to the president, Member Brown, and she had indicated that a representative would have been attending this morning in Vice President O'Neill Grant. So I guess we'll just wait and see.
Yes, and that's the information I just gathered, that
Right.
Mr. Grant will be joining us shortly. So we are to pick up Ministry of Labor at part 11, and I now ask Mrs. Bennett Campbell to lead us through this phase of the bill.
Good morning, everyone. So, clause 194 commences with enforceable undertakings that can be given to the director, now the authority, by a person who has committed a contravention or alleged contravention under the Act. The authority is not compelled to accept the undertaking. If the person fulfills the undertaking, criminal proceedings cannot be instituted in respect of the contravention, alleged contravention. And while the undertaking is in effect, the director or authority cannot institute proceedings in respect of said contravention. What the undertaking is really a voluntary agreement. So the PCBU would have put forward the proposal to enter into an undertaking. It is intended to be a precursor to any criminal proceedings, in that if you enter this undertaking and you actually comply with it, then the authority would not be taking criminal proceedings against you. So you're voluntarily complying, you have agreed to a proposal as to how you will be fixing the problem.
Yes, Member Gill.
This would be suggesting that once you have decided or accepted to comply, and you would have satisfied the requirements, it means there'd be no need for any criminal proceedings.
Yes.
And this is upon completion or to the authority's satisfaction.
Yes, because what happened is that in the agreement, you would have agreed with the authority the steps that would be taken to remedy the contravention. For example, you would have been agreeing timelines as to how this can be done. So it would have been a negotiation. It's an Australian concept. It's an agreement, basically, you're entering into with the authority. So it's a stay. So if it is that proceedings were actually instituted, you could then, at that stage before, you could have entered this negotiation with the authority, and it would have stayed. Those proceedings wouldn't have continued unless you are not complying with the contravention, complying with the undertaking.
You see, I asked that question because last week, in your absence, we spent a lot of time going through the prohibition notices. And so we want to be very clear as a committee that notwithstanding those notices being served, and there was even the question or debate around what would trigger cancellation of a notice. So we want to be satisfied that this premise of not filing proceedings would have been on the background, that you would have gone through some prescribed format that both parties would have agreed on in the pursuance of fixing the problem.
Can I query what you mean by prescribed format?
You would have indicated just now about a discussion, and maybe I don't want to use the term negotiation in this aspect, because when you negotiate, it's a request for either party to express a need, and that need by a person conducting business might not be in compliance with the directives of the authorities. And that's why any recommendation by the authority, if that recommendation is presented in such a format that the person conducting business cannot go outside of, or they would be in breach. And that's why, hence, my term suggesting a prescribed format.
Well, it was not intended for this to be a prescribed form, which is why I was asking about the prescribed, because the contents of the undertaking would depend on a particular contravention or alleged contravention. And when you look at some of the jurisdictions, some of it even entails you actually training staff who may have been injured in this particular matter. So it's more than just fixing the contravention, but other steps that can be taken. Mm-hmm.
Yes.
Chairman,
Yes, Member Brown.
last week we had a discussion, and I'm following up on Senator Gill's thing, where we said the myriad orders or notices, prohibition, improvement, etc. That we non-disclosure, number of them, and we say would fit them into thing. No, how does this undertaking fits in to this? Because having read the draft bill, it speaks to it's not an admission, can therefore be used against you. And if we serve the improvement notice, why would there need to be an undertaking? So I'm not clear on the philosophy behind the undertaking. And also, if there's an alleged contravention, why would I need as an employer to give an undertaking for an, if it's alleged, it's clearly we're not agreeing, and that's a violation. But you're asking me that I can give an undertaking for something that is alleged. I don't know how the allegation fits in with the contravention. Somebody who has committed a contravention, and whether the committal of that contravention is prior to or post filings in the court. Or I assume as an ASH officer or as the authority that you are in violation. Who determine the committal of the violation? So the philosophy behind this would be important for me to know, because it may also be unnecessary.
Ministry.
Yes. So the concept behind the enforceable undertaking, and it's a principle taken from Australia, which is why it's new to us. But it's meant that the PCBU would approach the authority, having been told that you have a contravention, or alleged contravention, and without having to admit liability, you can agree to take these steps. So it's something that you would have voluntarily approached the authority about. It's not something you are actually compelled to do. And then enter into an agreement to how you're going to address this. So it is really meant, so they would have had to have approached the authority to do this. And so it's voluntary. So you would then be agreeing to steps. So it's not something, so it's an alleged contravention, yes, because it's not proven. It's an alleged contravention. But you may have looked at the matter and said, okay, there's a possibility I may be found guilty, although I'm not accepting liability. So I want to approach this. Now, I must also point out that this section, though, is meant, when you look at Australia, it's actually linked to duties in 19.2. No, our bill. So it's, remember you set out the duties of care and the various duties? It is actually linked to that, and it's also linked to 31, 32, and 33. So you have basically a safety and health duty. It's alleged that you have breached this duty, and you seek to enter into an undertaking.
Mrs. Seeley Brown,
Again.
before you.
Oh, sorry.
Yes.
So why not just issue them with an improvement notice? Or any other notice that, in relation to whatever breach they would have committed?
We're just trying to give another avenue to actually resolve the matter without proceeding to court.
Mr. Chair,
Member Skeffrey, let me hear Sergeant.
okay,
You.
my apology.
Yes. Yes.
Morning. The Chambers does not support Part 11. We think it's adding an unnecessary bureaucratic layer to the whole treatment of what is already it's already a difficult bill. There are already a whole lot of steps, a whole lot of compliance steps on top of the registration licensing process. There are a lot of steps. In this did come from Australia. We have done some research. I saw something that it wasn't very positive. You have to be very careful about how we decide to take something from somewhere and put it in our system. This does envisage a court process, because if the person doesn't comply, then you have to go to court. And then how are you going to go to court with this new concept? We would have to carefully build it out into our legislation, because it is not a concept recognized here. I don't think we even need it. I don't see how this adds to the bill. I just think it adds an unnecessary layer of one other hurdle, because if the person gives the undertaking, decides not to go through with it, you have to take them to court. Why not then issue that notice where you have, this is a concept already understood in our law, where we have the notice, we have and repercussions that follow from the notice. There's nothing preventing a PCBU from trying to have negotiations with the authority, even when a notice has been issued. Nothing stops that, and that is part of our culture. When you have a regulator regulating entities, you're supposed to have that sort of relationship, and it's understood. And that's an administrative process. That's not something that you put in the law. But you already have that mechanism. Nothing would also stop a PCBU from entering into negotiations, even if a notice has not been issued. I just don't think that this enhances the bill in any way.
Could the Sergeant comment on 194.3 in the context of what you have just said?
Well, so this is part of the reason I was alluding to the fact that we would have an issue now, because when you look at 198, it says you can take them to court if they didn't fulfill the undertaking, but you have then 194.3, there's going to be an issue, which is why I said if we were going to, I decided not to go into the specifics, but if you are going to then bring this concept in, it would have to be very carefully outlined. There have been issues in Australia where the courts have talked about some of these undertakings are unenforceable, and issues when the courts were approached. So if we were going to put this in, we would have to do it very, very carefully. So 194.3 appears to be a hurdle if you're going to proceed under 198. So this is again why I'm saying it would have to be really built up very carefully. And I know the ministry had made some comments on some of it, well, not 194.3, but we just don't support it. We don't think it is necessary. And even having heard the rationale from the ministry, we still don't think it is necessary. And no, could just create additional issues.
Chair, you know, in this, how I look at it, I use the context of is either a mango is green or it's ripe. I'm not into this thing about a turn mango. I prefer, well, the green one you can eat with salt. Just for you, Senator Skeffrey. The thing about it is that if there is just waiting for Mrs. Bennekamp to confer with
You have our attention.
Mrs. Smykel.
Yes.
So here is the situation with the undertaking, in that if there is a breach, that breach ought to be fixed. Now, 194.3 gives a suggestion in my mind that there is no admittance of guilt. So I can go halfway. I don't have to fix it. Bearing in mind that the allegation can come from the employee's representative indicating that there is a possible breach, and that possible breach would warrant an investigation by the authorities. But once we start to get into this thing of an undertaking, it suggests somewhere along the line the possible of compromise. And what if my extent of compromise does not fully represent a total fixation of the breach? And last week, I indicated that the notice for improvement forms part of a record that a breach exists, and that breach ought to be remedied, and again, a prescribed format that outlines a stipulated sequence of events and timeline. So, whilst I can understand that the ministry would be seeking to find different measures in treating with it, all measure does not fit all persons conducting businesses, because some might seek to escape on the one hand. And so I'm of the view, Chair, that there must be some record of agreement in terms of fixing a breach. And so I'm not so happy with this notion of this undertaking.
Mr. Chair, I just want to also support that point. Because this section is really giving the authority some enormous power that you really can't apply with any clear objectivity. And for you to be consistent, there has to be a standard. And if you have this undertaking and it's really up to the authority, the OSHA officer acting on behalf of the authority, you're really not going to be able to enforce. You have your notices, persons are in breach, you give the various notices and they don't comply, then let's go to the court. The system will take care of that. But it's as if you want to give it the left hand and then take back with the right hand. So I don't know what you really want to achieve. I hear the argument about giving another chance. And it reminds me of clause 178, where we spoke about reasonable, last week, reasonable excuses, where we had some clearly listed exemptions. But then you put another clause about reasonable excuses. So it's as if we're afraid to enact what we really want to happen. So we say these are exempted, but you still have reasonable excuses. Here again, we have the notices, but we still want to have another provision. Let's be careful that we're not making the authority into a superpower that they cannot even monitor their own self. Because this is a bureaucratic institution that we would want to create that at the end of the day, no one will know exactly how effective the authority is. And therefore, I too didn't fully understand the clauses when I read them. And as I listen to the conversation, I believe we have to ask ourselves, this is where we want to go. Speak about Australia, yes, but it can't be just a linear acceptance. We have to understand our culture, our reality, as we seek to make this legislation, which is a new one. And we have to be able to police it at the end of the day.
Chair, I'll ask before they respond, I'll ask about the philosophy behind it. Because I go back to 183.2, which we have dealt with, which says it's not an offense to fail to comply with recommendations. We said we would not go the route of recommendations, but in the improvement notice, which is prescribed, certain specific things to be done would be stated. So it seems to me the draft went along the line of saying, well, we will tell you, we'll make some suggestions through recommendations, but you're not liable if you don't follow it, because the whole 183.2 said it's not an offense to fail to comply with recommendations in a notice. I think we have fixed that to say the improvement notice will say specifically what needs to be done. And it's against that background that I really don't think we need to continue along that line of undertaking, of these voluntary things. So I share the view of the AGC, which says we really don't need the undertaking. What we're going to have is a notice given, improvement notice we're agreeing, and it will say you need to put a cover over the fan, you need to deal with this chemical thing, or whatever the problem is. And that don't need no agreement from the employer. You're saying our ASH experts tell us that these are the fix, right? And then if they want to challenge it, so be it. But I don't think we need to add this layer of undertaking.
Dr. Robinson, you wish to?
Yeah, I'd just like a little bit I'd just like to understand this a little bit more. So with the whole matter of undertaking, am I to understand that this involves a step-by-step approach that leads to a permanent fix, but may also include a immediate temporary fix that will mitigate serious injuries or loss of life?
Ministry?
Yes, and we did recognize that we would have had a fight today because this concept is not known in our jurisdiction. We thought it was a progressive step, but at the same time, because it's not known to our jurisdiction, we know it would be a challenge. So I would like to just say though, because I wanted just to have the information that we have here, is that in relation to 194.1, we had said regulations will provide guidance and to the information that can be contained in the undertaking. This may include particulars about the person seeking to make the OSH undertaking, details of the contravention or alleged contravention, a commitment to cease the behavior that led to the contravention or alleged contravention, the time frame within which the undertaking must be completed, a statement of assurance about future occupational safety and health behavior, and a statement of regret that the incident happened. The authority would have ensured, because the authority is not obliged to accept the undertaking if it does not fulfill the criteria, if it does not meet the requirements to resolve the issue. In relation to clause 195, regulations will provide guidance as to the factors that will assist the authority in determining whether to accept or reject an undertaking and evaluation process, because we understood it could not be left to the authority with no guidance at all. This includes, I'm just going to finish this and then. This includes benefits to the workplace, industry, and the community. The following examples of what the authority can take into account when evaluating the undertaking: the circumstances surrounding the incident, the proposed undertaking's merits and benefits, the person's financial ability to meet the terms of the proposed undertaking, the significance of the commitment compared to the capability of the person's compliance history, the support the person has provided to injured persons, the input from somebody who may have been injured in the incident, and the likely outcome should the matter be dealt with through legal proceedings. So it really was intended that we would have had to give more guidance in regulations as to the decision-making process. But this was just another avenue that we thought could have been used, but we realized it's not something that is known in this jurisdiction, because we did have to read Australian law to be able to fully get the concept and to come back.
Mrs. Bennett Campbell, you weren't here, and I missed you last week, even though Mrs. Michael held her own. But what we're doing, this is a type of legislation that is making a great change in how we treat with occupational safety and health. And it is also promoting a shift in culture. And we are ingrained in culture. One of the challenges that is going to confront us is where we take a template from elsewhere and seek to impose that template here. And it can be done, but I would submit humbly that it's better we do it in stages. Let us see how we propose a means of treating by instruct to indicate that there are possible breaches, you have committed a breach, and you need to fix that breach. And let us see how that works before we start going to opening up an avenue to seeking compromise. Now, you weren't here last week, but you, by your own words, you suggested that you'll be coming up to a fight. We're not fighting with you, We want to work with you to make a type of bill that can work. And some of these things might very well come out in the regulation to support it and to complement it better than to prescribe it in the legislation. Because in the first onset, Dr. Robinson's team and the battery of lawyers that he can afford. Les is not here this morning. But the battery of lawyers that he can afford might want to respond to to indicate, but why you never got to the undertaking first? Because that's a possible option. Now, in 195 A, B, C, D, and E, those can be viewed as mitigating circumstances that can be utilized once you serve the improvement notice, that you can have that conversation. And the regulations can address that. Right? So you might be on to something, but we don't have to utilize all that compromise this Australian model. It might be too big for us.
Mr. Simmons.
Thank you, Mr. Chair. Well, let me say, first of all, that the Legal Reform Department certainly would not be in support of the creation of additional offenses under this section, certainly for example, sections 197 and 198. It sounds very double jeopardy-ish. It's not double jeopardy, but it sounds that way because someone can potentially be charged for the same offense in two different ways, by virtue of the undertaking and by virtue of the breach. However, I'm not going to totally knock as yet the the undertaking, bearing in mind that it was discussed last week and agreed that we'd want to put in a type of tiered approach. My understanding would have been before the issue of the improvement notice. So in that regard, I would certainly support the AGC where the normal approach is when you're regulating an entity that there is some type of discussion, depending on the type of breach. There's normally some type of discussion. So it doesn't necessarily have to be in this forum, but I don't know to what extent the undertaking could be factored into the tiered approach. So in that regard, certainly we don't need a separate section for enforceable or OSH undertakings. But I would like to see how the tiered approach, I don't think the ministry or the CPC have yet discussed it, but let's see what the tiered approach could look like and then take it from there. But I certainly think it should be before the issue of any notices. Thank you.
All right, let me hear from Mrs. Celia Brown and then
I thought
Soldier.
we agreed last week, Chair, that we weren't going to leave any sort of discretion to these OSH officers in relation to outside of the compliance and other notices that they may issue. So I can't see it working in that way. And I hold the view that the AGC chambers hold that if you have you've set out your different types of notices, there's no need to have undertakings. And the conflict also that arises because you're saying in one vein that it doesn't constitute an admission of guilt, but yet still you can go to a court, you can have a court order being issued for implementation, and then you create this offense for failure to contribute. And I don't think it would take away anything from the strength of the bill if this part is taken out.
Soldier. Okay, all right.
Mr. Chair, just quickly. You
Yes,
see,
let me hear.
as I said earlier, this is a new pathway we're taking. So we can't want to achieve everything at once. And we spoke about regulation, but the experience, technical team will know more than I do, the experience with regulations. Up to this morning, and I heard that the Road Traffic Act won't be implemented, no sections of it, because of regulation. And many things that was put in there, and we were warned that let's move a bit. And then we were told regulation, not yet ready. I'm just saying the bill will have a review period, I hope. Naturally should. So, yes, I'm saying let us ensure, so these technical issues that we don't even know how, we're going to put it in legislation, even as worded, is not as clear as it ought to be, and then it needs regulation to drive it naturally. I'm saying let us look at some of those things that we can move with quickly, and then this aspect, because this doesn't prevent you from achieving the objective. Once you have the various notices, they are properly served, and they have the standard approach going forward. So I think that's really weird, because if you include it here, the how, I'm not clear on.
Yes, Soldier. Yes.
No. I had a senior moment a while ago. What I still am unclear on is when this would operate. In the context that we already have notices, and there's nothing in here that says, okay, so the first thing is it can operate where there's a contravention. It says in relation to the contravention or alleged contravention. So it suggests then that you could still, someone could have been issued a notice. Would there be a stay of the notice if an undertaking is, what is it, issued? Or how would those negotiations occur? I'm unclear on when this would apply in the context of the scheme of the bill where we already have a notice provision where we can issue different notices. If a stay would not apply, then how would both work at the same time?
Ask a question, Chair. Just to eliminate.
Yes.
Mrs. Bennett Campbell, was this meant for a hybrid type of situation? Either or, you can exercise any of the options? Was it meant for that? I don't know. I asked a question.
As an alternate to notices, is that what you're saying?
No.
If the undertaking was meant to be an alternate to the issuance
In terms of an approach,
Okay.
you identify, you see, it can come into a number. There is a flagrant, blatant breach, or you feel that you may be committing a breach, or there's a report of a possible breach. Now, once these circumstances have represented themselves, I just want to know if it's a hybrid type of situation where you can collectively or jointly select to utilize any of the means.
Mr. Baker, you wanted to say something?
My mind, sir, badly. Well, I'm just saying that once the act comes into being, the population will be sensitized to the fact that what are the do's and what are the don'ts, what they need to do. So, from our point of view, we always the act is there as a guide. We conduct investigation, and we give sometimes verbal instructions, a kind of dialogue, and ensure that the persons, before we go into serving of a notice. So in this regard, the other complication with the undertakings and so I think will kind of complicate the process. And we have to look again at the wider picture. How do we effectively enforce these act regulations with our kind of settings, with our kind of developing? Because when you take in a first world country, they have some certain mechanism already entrenched. So all of this we have to consider in respect to how we proceed.
Ministry? Yes.
Well, we did recognize it, started with legal reform, although I don't know if I remember all the questions at this point. But in terms of, we did recognize the duplication, which is why we were asking for the double penalty to delete 197. It was meant to be another option available to secure compliance. Now, we recognize that at this point, we may not yet be ready for a provision like this in this jurisdiction, and the bill is to be reviewed by another joint select committee within 5 years based on the provisions. So if we feel strongly about the issue after the act is in effect and when we have seen some gaps, we would be willing to revisit that issue at that time.
So the ministry is guided by the recommendation of the soldier?
Yes, we are. And seeing that after the bill is in effect,
Yes.
and we see if there's a weakness where this could have assisted,
Yes.
then we would then try to revisit the matter at a later stage.
Very well. So what is before us then, members, is the removal of Part 11 from the bill?
Chair, as I understand, just for the record, it is not just the Solgen who has said this is.
Yes.
I hear from legal reform.
Certainly.
I hear from the Parliamentary Council.
Yes.
So all three of the legal
yes.
have said it's not a wise,
Along
it's
with
not
the
prudent to
committee.
have it there.
Yes.
I share their views, and
Yes.
I'm happy that the Ministry of Labour
Yes.
is agreeing with that. But it is not just the Solgen.
Yes.
It's all of them.
Very well.
And I accept the
The
view
whole
that
house.
this is for the future. And the truth be told, we're
yes.
trying to move away from court. And this section takes us back into the court, including getting the court to get people to comply with an undertaking that they have not undertook.
Very well. So members agree to the deletion of Part 11. So ministry, that will now take us to Part 12 of the bill. I know, you get it. That will take us to Part 12, yes. Yes, Mrs. Benny Campbell.
Readjusting my papers very quickly to get there.
Very well, very well, yes. Just indicate, members, that we have, going back to an agenda item, apologies for absence, that member Webby and MP Ferguson, they have both sent their apologies. Yes, Webby and Ferguson. Yes, Mrs. Benny Campbell.
Yes. So, part 12 addresses review of decisions. And it is also linked to the 7th schedule of the bill. Okay. So, what we are proposing, we have had examined how these provisions are addressed in this jurisdiction generally in relation to authorities, body corporates, and we have realized that there's a weakness in the existing bill in that there was no proper mechanism put in place for who would actually review the decisions, in this case of the authority. So what we did, we had a look at other legislation, and we're proposing a deletion of the Part 12 and 7th schedule and replacement of same by the provisions that we're putting here. This was drafted more in keeping with the New South Wales model and not in keeping with this jurisdiction. So we tried to make an adjustment based on feedback we received in other sections as to how we'd approach this. So I'm going to enter into the proposed amendments.
Yes, Member Gill.
It was the reviewing of decisions that would have been taken in other sections that is seeking to propose these new amendments.
So what we are trying to address with these amendments is a proposal for appeal of decisions of the authority, basically, in relation to registration. And there are decisions that have been made by the authority, and a mechanism for that to be actually reviewed.
Yes.
All right. So we had set a review committee is to establish the hear appeals for decision of the authority, but we were having a little discussion with legal reform prior. They can come in, but we were trying, the legislation called this body generally appeals tribunal. When we look at it, we didn't want to use back the tribunal because we have another tribunal. So I don't know if we could call this an appeal committee, for example. Because what is generally called appeals tribunal.
Work. Because I think we're moving away from the tribunal. I think we were moving away from and the tribunal because earlier. So how does this fit in with the tribunal under this act? This bill?
This is not to do with the tribunal. This is a mechanism. So that tribunal will be looking at conciliation kind of matters, the Occupational Safety and Health Division of the IDT. This is talking, and that's why we didn't want to use the word tribunal in this context. This is where the authority, for example, has decided not to register an establishment. What is the mechanism for you to get another body to look at that? So it's not the US tribunal, and that's why we don't want to use this. It's a mechanism for review.
But would it review also my refusal to work? As an employer, I said to Mr. Robinson, boy, this is unsafe, I'm not working. Your ASH officer says, no, man. Or your authority says, no, it's safe. I go to the tribunal or I have room to this review committee?
You go to this committee because at that stage it's a decision of the authority who would have told the worker to return to work because we do not believe that you have a valid concern. So it's a mechanism to review the decision of the authority. In that case, who would have sent the USH officer into the workplace.
So I know another layer between me and the employer, the ASH officer, the review committee, then the tribunal.
No, this is to review the decisions of the authority. We have used the tribunal so far in two contexts, the IDT for the shorter version, in two contexts here. We have so far used it in the context of reprisals, and we have used it in the context of OSH issues, which is not yet resolved. We did not have right to refuse unsafe work going to the IDT because we said that would take too long. So what we had outlined, which we probably have to outline again, is that the OSH officer would have come in within a certain time, assessed the situation, and made a decision as to whether the worker should have refused unsafe work. So it's two contexts in which the IDT has come into this bill.
In other words, Chair,
Yes.
what this is seeking to do
Yes.
is that having given the authority this awesome power,
Certainly.
then somebody or some grouping or some panel
Very well.
is being established to review the decision of the body that has been given this awesome power.
That is exactly it, member.
Okay.
Yes.
That is correct, because we have been hearing the concerns that this authority has so much power. And when we look at other legislation, you see that there's normally something put in place for you to actually hear appeals of their decisions, and it helps the balance, so to speak.
I am now understanding it, Chair.
Okay.
So let us now look at what that review committee
Yes.
is able to do.
Yes,
Right.
Sergeant. Yes.
Right. I think part of the confusion is because while we've been reading the bill, there was no signpost. So in every other law, what you will have is you'll say that a decision is taken for licensing, and then it says this can be appealed or this can be reviewed. Throughout this bill, you didn't have that signpost because it's now set out in the 7th schedule. And it's the 7th schedule that's on page 182 of the bill that gives you a long list of all the things that could be referred for review. So I think that is part of the issue, because if all along we had been alerted to the fact that these are the different decisions that will be reviewed, then it would have helped to give the context. But the problem is that that is in the 7th schedule. There is another reason why laws have this whole concept of an appeal tribunal. In fact, there was a matter that had to go to court involving the FTC, Fair Trading Competition, Fair Trading Commission, where their law initially had provided for them to be an investigative body, and then they could review decisions, and then they would hear those decisions and take decisions on those decisions. And that went to court, and the court said, no, you can't do all of those functions. So the reason you usually have an appeal tribunal is to have a separate body assist an authority in conducting a review, because every authority, there has to be some mechanism for a review. If you don't provide for it in the law, what it means is the person would then be able to go to full court, and you don't necessarily want that mechanism. One, it's too costly. The courts can't manage that kind of load, and also you don't want your everyday user to be forced to have to go to court on matters that are administrative and also could be reconciled easily without involving the judiciary. So normally you have this other mechanism. Doesn't have to be called an appeals tribunal, but just a mechanism that will meet the criteria of a fair hearing. So it should be a separate body. It can't be the same persons employed to the authority that would then be reviewing decisions of the authority. And you have certain mechanisms, and some of it is set out in the ministry's document. But just to explain, it's not just that it's a feature you see in other legislation. There's a reason for it, and there's a very good legal reason for it. And then just to direct members to their attention to pages 182 onward that indicate the matters that would be under review, which of course some of these may have been modified depending on decisions we took earlier in the bill.
Okay, very. Yes, amended. So the reviewable decisions are contained in the 7th schedule. Yes, Mrs. Silibra.
I would suggest, though, Chair, that whatever we keep in the 7th schedule, we, as Mrs. Aldred said, we have that signpost in that particular provision. Don't put it all at the back of the, of the bill.
Very well. Yes, yeah.
Given the landscape in which we operate in all workplaces, this strikes me that is going to be a permanent, it's going to be a busy body. A busy body. And therefore, it might very well turn out to be the tribunal. And I'm not sure whether or not we want to, because if what is going to go to the IDT type is victimization, reprisal, you said, right? Then that sounds to me that it could go to the ordinary and existing tribunal, which every day deals with disciplinary matters. What was the other thing that would go to them?
We have not yet resolved OSH issues. We had contemplated OSH issues going there, but we had not yet finalized OSH issues. So those would have been the two things.
Reprisal that we're looking at now, that could go to the ordinary IDT without establishing thing anew. And that we really will need, with a consequential amendment saying that this is not acceptable, just as I think we have it in other legislation of the LRID. But what will be key here is that we need to, from a policy point of view, decide whether we establish a review tribunal for the ash matters and call it that. Because it could be a heavy load. I said busybody, it could be a heavy load. It could be people from Westmoreland and all coming in with their complaints. And if you have something that is ad hoc, it may not meet the load. So that's something that I think you need.
But Member Brown, I believe, before you come in, Member Gill, I believe there's a section of the bill that deals with that IDT type tribunal. So the points you're raising, I think we could save it until we get that to that point. Yes.
Situation, Chair.
Yes.
So this authority is a regulated institution. And you would have had other legislations that establishes a tribunal to treat with the decisions taken by an authority. You're saying no? No, I am saying in other legislations, not specifically this one. What this one is seeking to do is to establish a tribunal that deals with issues that has not been resolved when with the persons conducting business and the employees. And workers. And our workers. This part of it is seeking a different type of terms of reference that, in my mind, is specific now to the decisions of an authority. So you have two appellate bodies treating with consequential matters. Right? The issue, however, is whether or not an individual may feel aggrieved with the decision taken by this review committee, and where is that step of other step of application?
It appears to be the court, but I'll hear from Sergeant. Yes. Yes. Yeah.
It'll be that, yeah. But I just wanted to ask, Member Brown, I just wanted to confirm something that you were saying. Is it that you are saying that you think that there should be one body dealing with all of the reviewable decisions or appeals coming from the authority, rather than have that particular body under the Industrial Disputes Tribunal dealing with a particular type, and the review committee, or whatever we're going to call it, deal with the types that, the decisions that stem directly from the authority?
I'm saying, through your chair, that there are two set of issues that could arise from them. One having to do with the PCB, the person conducting business, and the worker, where reprisal comes. That need not go to the review committee. That could go straight to the IDT without creating another IDT arm or whatever. The other matters go to the committee, which should be skilled and comprise people who could address those technical issues. So that I hope that explains where I am.
All right, Mrs. Benny Campbell, proceed. I know you had raised the matter of what do we call this committee? I don't know if Soljan, you had a point on that. Yes. Yes, Mr. Simmons, let's hear you on that.
Yeah, I actually prefer the term appeal committee rather than review committee, since that's what the appeal committee rather than review committee, since that's what the committee is actually doing.
Mr. City Brown, wait.
I'm in agreement, sir.
Okay,
Yeah.
so we will proceed with the use of the words appeal committee. All right, Ministry, you may now proceed.
So the Solicitor General is right in that the decisions that can be reviewed are set out in the 7th schedule. We would have to revisit that because quite a few of those provisions do not exist or have been changed. Even Yes. So yes, there have been numerous changes, and also in terms of the redraft, some of the sections will not match until we actually have a bill. Like we redrafted registration, for example. But we're just going to go through the general concepts that would apply and the constitution of this body.
When we going back through now, we would actually determine, yes, which ones will go, yeah. Yes.
Yes, that's understood. Yes.
So just giving a general idea of decisions that could go, making, suspending, canceling, or refusing to make an order, determination, or decision. Legal reform had raised something there. We're not sure that the authority made an order. We're double checking that. I know they make decisions. Making a demand or requirement, failing or refusing to register an establishment, canceling registration, or failing or refusing to renew such registration, doing or refusing to any act or thing required under the act or regulations. Well, I think we may have to, I don't know if we're going to go back to the approach, I think, where we actually list the sections in question. I think that might be better for this particular bill.
Chair, again, going back to those myriad of areas that we had identified.
Yes.
And then determine whether or not either we expand this list to cover them, or they are captured, to determine if they are really captured in 1 to 4.
I think this time we should. Yes.
Just to say though, it can't be. So I think this is just to give you an idea, but you wouldn't have a provision that is set out like this because it's too vague. There has to be precision when it comes on to whether you actually have a right of appeal or not. So it would have to be at every section. Whichever section is going to, that can be, where a decision is taken and it can be reviewed, it has to say so.
Yeah. Saying to me then that you'll have to go back in the bill to look at those areas and identify with the with the notification that this particular area is subject to appeal.
Yes, I am saying that the committee has a lot more work ahead of it.
Yes.
No, remember
Yes.
again in our chair.
Yes.
Remember again in our chair
Yes.
that we are going to have to go back through them too.
That is true. But I think the 7th schedule is already there. That gives us a guide.
Chair, if
Yes.
I may
Yes, Member Longmore.
emphasize that if at that process, as best a medical input that you can have, a lot of what you're actually dealing with, especially in the earlier definitions, etc., and the basal offenses, etc., that you get a direct representation at the board, at the table, from particularly medical, but mental health. Okay, so thank you.
Very well. Mrs. Mary Campbell? Oh,
Just
Member
some
Brown.
concern. I note the reliance on the Fisheries and the Jackra Act. And the Solgen knows exactly what I'm going to say.
Yes.
She knows exactly what I'm going to say, which is why she has chuckled.
Yes.
Molly, you right? That's why she chuckled. Yeah, LOL, sorry, different language. No, essentially, Chair, I'm just wondering, from the multitude of tribunals that we have in the system, and I'm wondering if one day the AGC would provide us with the list of different tribunals that exist under different legislation, so we can shock ourselves into seeing how much more we create each day as we come to a new legislation, and whether or not we shouldn't be bringing some of them together. But is this the best best act from which to draw
Well,
the committee?
I'm suggesting, Member Brown, that we perhaps should allow the ministry to walk us through and we take it as we go along.
We were at the point where we're saying that they're not ready with the 7th schedule yet, that they would have to go back and redraft it, because
Yes,
if you're going to walk us through this.
Yes. Yes, Mrs. Seeley Brown.
I don't think, Member Brown, that we're even going to have a 7th schedule if we agree that wherever you have that right to appeal to the appeals committee, or you have that right to appeal to the tribunal, you put it in the specific section that provides for whatever. Yes. Yes. So we're not going to have the 7th. Yes. 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 I don't think we. Yeah.
But just to point out to the ministry, so matters as Mrs. Seeley Brown was bringing to my attention. So the items on page 183, like number 5 and number 6, those are not matters that would have gone to the appeals committee. Those are matters that are dealt with in court.
Yes.
Actually, remove those provisions. That's part of what we have to be to compare with what we deleted.
Mrs. Mary Campbell? Yes.
Minister, it's been brought to my attention that we had said to the committee that when we were finished the notice provisions in terms of prohibition, improvement, we would have gone back, because remember the ministry was asking for deletion of provisions related to seizure and forfeiture, and the committee was to revisit, having looked at what was presented, read the notices to see if they were satisfied that we did not need those provisions. So I'm understanding that that was not actually done when we were finished with notices last week.
Yes, but we will have to revert to the committee in that regard. So at a later date, we'll get back to the committee in that regard.
Right.
So you may proceed now.
Yes, so what we did is put forward some general provisions. We were not trying to draft the provisions per se, because there are some general provisions that apply, but just to give an idea. All right, a person who is aggrieved by decision of the authority under the Act or regulations may appeal to the Appeals Committee by notice of appeal. This application is to be made within 21 days of the date of decision of the authority. The notice of appeal is to be served on the authority and should set out the grounds of appeal. The notice should be accompanied by copies of any correspondence, document, or statement relevant to the appeal. A schedule to the Act should address matters such as the establishment, composition, jurisdiction, powers, and procedures of the committee. We are guided by some of the general provisions, including the 3rd schedule to the Fisheries Act and the 7th schedule to the Jamaica Agricultural Commodities Regulatory Authority Act 2017. So those are just some general provisions, but other laws can also be used to guide. However, the following is some of the information to be included in the schedule. The minister will appoint the members of the committee. The members should consist of a chairperson selected by, we are going with the tripartite approach at this point. The minister will appoint the members of the committee. The members should consist of a chairperson selected by the minister who appears to have knowledge and experience in occupational safety and health, one person nominated by an organization representing employers, and one person nominated by an organization representing workers. Legal reform to come in.
Mr. Simmons?
Yes, Mr. Chair. I had actually had some just informal discussions with your team earlier. I have no difficulty with how the committee is appointed. Safe to say that the persons who will be nominated by the organization representing employers or person nominated by organization representing workers should also have some experience in occupational safety and health.
Members? Gill and Brown?
Well, you always want a committee of this nature with competence. So there's nothing wrong with that, sir.
I don't think we need to say that the person, we may never get somebody from the worker side, for example, or from the employer side. So I don't agree with Mr. Simmons on that. But certainly these organizations who would be making recommendations ought to take that into account. And if you go to 2, it says the committee may have assessors who are pulled from skilled persons, so that the common sense of the employer rep and the worker rep would benefit. Or else we may never find a chairperson who wants to come and serve on this committee, who have all of the skills we need. There are few of them, you know. Few people who are really, as Mr. Mahan will tell us, that is in this category.
Member Skeffrey?
Yeah, I do support Member Brown, because I don't know if it's necessary that all members must have knowledge in that skill area. What you're going to do, as you say, is a appeals committee. You're going to ensure that you look and see if justice was done, the laws and the regulation that you have, and what you summon the persons for, or what the contraventions were, that it is done in accordance with the law. And therefore, it doesn't mean that everybody must be a skill set. There are some people you want to have through another lens. And sometimes what the skilled person will go down a particular road, the non-skilled person will see a different lens. Just like when jury system, and just like when the technical team makes a bill and take it to the Senate, for example. We are all not lawyers, but we can see it in a different viewpoint and put your no, we are not trained lawyers. We didn't go to normal law school, and so you're enforcing the point by highlighting. So so I understand. While I can understand the thinking, I don't agree with it. Just like state boards, there are some persons who sits on a board, not necessarily a technical person, but you are able to see through, because sometimes technical persons look down one lane, and sometimes there's a better lane. So you want the quote-unquote ordinary man. So I don't agree with that. But secondly, part 2, is there a cap to the number of persons that you may cut? Because I said the committee may cut persons Or you caught them for a specific period and when that case is heard? I don't know. How do you? So once I'm co-opted, I am co-opted for the 3 years. So if that's the case, what's the cap? So what's the composition for the committee?
At this point, it's 3, the tripartite, but underneath, you would say the committee make up persons who possess the requisite experience in any matter being heard. Purposes of these persons will be to assist the committee. So in a particular matter before it, the committee may get assistance.
So will
these persons, of course, cannot
So
make
will
a
this
decision.
co-opted person has voting rights to make decision?
No. It was
But it's not stated there, no?
I know, so that's why I added it before you asked me. Because I realized it.
But why? No, but if you see the legal, if you are selecting persons with competence, however you define your competence, why do you need to call up other person with skill area? Is a tribunal or it's appeals body? So you select these persons, in the minister, in his wisdom and best advice, select 3 persons. And you have them as the appeals body. Why do I need other persons to advise the appeals body? I don't see the logic in that. So 3 of us sit and we make a decision and we rule. I don't need any advice. If I want advice, I go do a research informally before I make a decision.
All right, Member Skeffrey, I want to hear from...
No, I want to understand the thing.
Yes.
I'm not, you see, I don't... Is this the norm? What is the precedence for this? And if so, guide me.
I will ask Ministry, I will ask the AGC to comment on that. And Mr. Simmons too. We'll hear from the lawyers because we may have some challenge with point 2, but I want to hear from Member Longmore before. Yes.
Thank you, Chair. And good morning, everyone. Mr. Simmons's recommendation read the requisite for the employers and workers. Whilst I recognize employers, because you also have employers who inherit a business and never work a day in their life and they have no idea what the reality is for a worker. So that's the reality too. You have to deal with that situation too. But a worker, their experience is they're a worker. That's their occupational health and safety thing. They're working and for a minimum time. Yes. And any worker should be entitled and feel that this level of representation they can aspire to, in my opinion. So I think maybe if we say a worker of a minimum time period themselves, but I don't think, but whereas employers, yeah, I could see where maybe a course or something that a sensitization process that they need to do that also if necessary, right? Now, again, my concern is the membership and the lack of reflection of a healthcare professional. Who will fully, immediately understand the full extent of the damage. Some won't, but you get a better chance that some would, and especially after a certain amount of years of experience. A lot of our legislation relates to the health of our people, and the consistent lack of that input in the drafting of legislation can be inefficient. You'll get the job done, but it's not the best job in my opinion in that respect, because at the end of the day there is also probably an efficient process that can happen with the immediate knowledge. So here it is that you have a committee that is to review the level of damage and the right to compensation, etc., of an individual with respect to the damage being primarily to their health, and you don't have that direct consideration at the board. And at the same time, Member Skeffrey's suggestion regarding the limitation on getting in expertise, etc., would mean that you want that level of expertise at the table initially. So,
yes, but
yeah.
Member Longmore, this is a tribunal that will be established to review decisions of the authority. I do not know if the authority, I doubt that the authority will have the powers to make an award.
Well,
yes.
Not even award,
Yes.
but to just contemplate the situation, just to consider, to deliberate.
Well, it is a tribunal, and I believe Member Skeffrey has made a point that is worthy of some further examination, and that is why we're going to hear from Mr. Simmons and the Sergeant just now. Yes.
Yes, Mr. Chair. With respect to the comments made by Member Brown and Member Skeffrey, you have to bear in mind that the OSH officer or the authority are technical persons. I'm not saying for all decisions made by the OSH officer you necessarily, because I can't think of all the situations now, but this is going to be a review tribunal. And if it's a review tribunal, I don't know of any tribunal that does not state the qualification for the persons who are going to be reviewing the work of the technical person. It can't be someone, in my view, who does not have some minimal qualification for treating with the subject matter. It can't be a lay person, in other words, in my view. Right? You can look at all the review tribunals that we have in statute. You don't appoint lay persons to sort a body like this. Okay. I also have a further point that I would have recommended that a lawyer also be on the committee. A lawyer would not necessarily be an occupational safety and health expert, but because of the lawyer's training in interpreting legislation and sifting through facts, I would think a lawyer should be on this committee. And also regarding procedure as well. So, but to simply, and I don't believe the section really contemplates simply appointing a worker or simply an employer, because a worker and employer may not necessarily have the skill sets to sit on a review tribunal, but they can still nominate the person in their opinion who can best serve on this committee. That's the way I see it there. Thank you.
Before you come in, my understanding here, though, is not that for every incident, the connected employer is going to be putting forward a rep. It is my understanding that the employers' organization, for example, Jeff Employers Federation, is who is going to be putting forward the person to sit on, yes, the umbrella.
Chair,
yes.
Just before the ministry, I just want to deal with Mr. Simmons' point. He's right when he says a lawyer could be. But there's nothing to say that the trade unions or the employers couldn't appoint a lawyer as their rep. But to insist that such a person must have experience in occupational health and safety. No, he says the lawyer does not have it. So this is what I'm saying. You don't need to put that condition there. You need to leave the organizations at their discretion to put people there. I can see a worker who has gone through training in this bill, functioning elsewhere, functioning on the committee. I understand, Chairman, so that. And I just want to say, Mr. Simmons, I've seen some big cases decided dealing with occupational health and safety that have nothing, that the people there are not trained in occupational skill. Yes, there are lawyers. One that you would know from Brownstone, Chairman, that famous case of the concrete mixer. A 40 million award. And I think it might have left some people in bankruptcy or pretty close to bankruptcy. It wasn't decided. So I don't think you should stick to the view that it has to be. But leave it to the organization to be sensitive. And of course, they need to tell us, is it going to be a panel of 3 only? Or is it going to be like other tribunal with multiple panels? What's the workload that you're going to expect? But I don't want to go further than where they are. But I'm just saying, and the composition, the chairperson, the way it is formulated in most legislation is who appears to have knowledge. And that's sufficient, you know.
Yes.
I want to direct the ministry's attention to C.
C or point 3.
Sorry. You have 1, A, B, and C.
That's back on page 1.
Back on page 1.
Oh, very well.
And I know in another legislation, the time frame for application is sensitive, and quite rightly so. In this case, the application to be made within 21 days. But I always like also a commitment from a review chamber to determine the time frame in which you make your response. In the IDT is 21 days, or they can ask for extension. And in this case, you know, the timeliness of a review is very, very important, because it's determined whether or not you can continue doing your business. And so there has to be a commitment from this appeal body to indicate the time frame in which you make your response or your judgment.
Sergeant?
I have a number of comments. None to do with the actual composition. But I was a little concerned when, although it doesn't say so, it appears as if it's supposed to be, and I know Mrs. Bennett Campbell was saying a tripartite, so I'm assuming the committee will be 3, but we shouldn't assume. It's supposed to be actually set out. Having regard to the matters that could go before this committee, I think a 3-member review appeals committee is going to be stretched. I think it should be bigger, where you have panels.
Mr. Chair, sorry, just to say that when I made my comments, I wasn't fully aware that it was 3, because I was actually looking to try and find what an... okay, so yeah, so in that, I mean, I'm thinking at least 5 or 7 members. That's 3 is I agree, if that's
Are you saying 5 members to hear one matter? Or
you could have a panel, so where you have a panel of 3 to hear a matter, but you have to have the appeals committee established with, say, so you have, say 12, and I'm just throwing out a number, say 12, but a panel of 3 can hear a matter. And in fact, I think, looking at the types of matters that could come, I think although it is part of common law, and usually we have a provision, although I don't see it here, that says that the committee will govern its own procedure, which usually means they make their own rules. And so we have examples of rules being made and established in very formal ways, like the Access to Information Appeal Tribunal. You have some that are less formal, but you leave it to them to still govern their rules and explain their rules to the persons coming before them. That's not in this document as well. But to just go on then to say for number 1, I think number 1 should give some capacity to have a bigger tribunal where you have panels being set. And then, so when you're having the discussion about the composition, if it's a bigger membership, then you can decide who would sit on your panels. So you have some laws, for instance, that say you must have a person with a certain skill set on a panel. It could be that when the chairperson looks at the matter that is coming before, they could then determine out of the membership, who would be the best persons to sit on that panel. It could also be that you're going to look at availability of members and so it could help to resolve some of the issues in terms of composition. When you go to number 2 with co-opt, you don't deal with a co-opting situation in this sort of appeal committee. That is more for when you have a board, and a board can co-opt members to assist it. With this matter, remember now, you have to have some formal process, whether it's an in-person hearing, virtual or not, or a paper-based hearing. There has to be fairness to the matter. So there should be an allowance for whether the authority or the person to be able to bring their expert evidence, so to speak. So if they need to have a doctor, that should be accommodated by the review or the appeal committee, but not that the appeal committee will co-opt members. That could do some damage to the whole fairness thing. Now, of course, the appeal committee should perhaps still be able to have assistance being provided to it, and perhaps this is what was the intention here, but it's not expressed in a manner that is usually that to me it doesn't fall within our rubric of natural justice, the way how it is expressed here. I do know of committees where review appeals committees, and I call that, but appeals tribunals where you don't necessarily have an attorney sitting, but what they will do is, we have examples where they ask the chambers to come and provide assistance to that committee in terms of legal assistance. And we have many of those examples in our planning and environmental appeals, whether to the minister, because remember too, we have concepts where the ministers hear appeals. Most of the ministers won't be attorneys at law, so what they will do is just get that sort of assistance. But again, that is usually set out in the rules that govern the committee. So those are not always things that are set out in the law itself. But co-opting is not quite the terminology, and it doesn't really, to me, conform with our natural justice principles. In terms of in C, I noticed the 21 days.
That's 1C. Yeah, C, yes.
Sorry, yes, 1C, that the application must be made within 21 days of the date of the decision. I think some discretion should be built in to allow for the expansion of that time in circumstances that the authority may deem fit. Things can happen for all sorts of reasons. And the types of decisions you're reviewing, it could be that somebody is ill, and from an USH issue, and there is an illness and the person can't even give proper instructions to somebody else. Right, so I think even if you
grant
keep,
that extension?
it would be the authority. So whoever you're applying to would be the authority. It would be the authority. Sorry, the review, the appeal. The appeal committee, would be the one to, in the circumstances, determine whether or not they extend the period. And I think you really should reconsider the 21 days. It does seem a little. But the thing is, if you leave discretion, perhaps there's nothing wrong with putting 21 days. And then, of course, whatever is served is supposed to be served on the other side. So when you say it is sent to the authority, then there has to be something to say that it is also served on the other side. So there are few things that are not included in here. And I guess I don't see anything about it would be in D4, the decision of the committee, not just that it should be a majority vote, but it should be in writing and it should be communicated forthwith to the parties. I don't recall seeing that in here as well. And reasons should be given. But I also think because of the nature of this, there should be some capacity to allow for a paper-based hearing, that you may not always need to have that oral hearing, because there's also cost that goes with the oral hearing and the types of matters that go. But I think that is something where you could indicate that it can be paper-based, but the person can ask for the oral hearing, and if the person asks for it, then it should be granted. Because again, we have a lot of cases on that sort of thing, but I think we should also perhaps write that into this law so that it is clear for all the users, because the persons who are going to be using it are going to be varied, and at least we should try to give them that kind of guidance. And as you go through, I may have some other comments, because there are a few other things that are not included in here that we usually try to put in when we're dealing with a review appeals committee.
Another one,
Chairman, sorry, go ahead.
Another one, if you look at 7, the office of the member becomes vacant if the member resigns his office. his or her appointment is revoked or the member dies. Now, you might have a situation where the panel might be in the middle of a review. Do you restart or do you continue?
There's usually a provision that puts in that you can continue because that could create a lot of problems. So if it's a panel of 3 and one person becomes incapacitated for whatever reason, the other 2 should be able to continue with it. And there are general, usual provisions, right, that it says it doesn't invalidate, but it allows them to continue those proceedings and conclude those proceedings. So those are usual standard provisions that are usually inserted in here as well.
Chair.
So the point out is for the inclusion of those sets of rules.
Very well. Member Brown?
Yeah, Chair, earlier I made the point of moving on beyond this, because what we have before us is a general policy direction, but not a proposal that would form the basis of legislation. And the Surgeon just went through a litany of issues that ought to form part of it. I believe that there are models that exist from which we can pull. One that I'm familiar with is the Labor Relations and Industrial Dispute Act. It sets out a schedule dealing with the composition, for example, of the tribunal. That's something we could pull from. It sets out in the law about what you do if a member becomes unavailable. And it's very clear whether you start de novo or you continue. That exists. So I believe whether you use JACRA, whether you use the fisheries, whether you use the LRID, find the model you want to use and come to us with specific proposals for the legislation. If they do that, then the committee is in a better position rather than trying to flesh out. I could see many areas of weakness in the document, but this doesn't carry us towards the bill. It carries us to policy choices. So for me, I'm proposing that whether you take the LRID approach to the committees, that's one, or the many other committees, review tribunals that exist. There's one in the Ministry of Health, there's the JACRA, there are so many of them with a template that already exists that we can cut and paste and make the changes necessary. So with this, I believe we are going to be wasting time if we just go through this and not recognize that what the committee needs is a set of proposal that this is what the tribunal will look like on the approach. So, for example, the question is this going to be panels? Is this going to be one single of 3? All of those issues can be resolved. The way the IDT set it up is that it says, and pardon for going there, it says we have a chairman, we have a set of deputy chairmen, we have panels of, I think, it's not even legislation, but it says essentially you can have 3 or 4, and in case of emergencies, you can have special panels, which is a feature we may want to look at, which take Mr. Simmons' point into account, that you may need a special panel and therefore you have to employ people for that specific case, given the complexity and the need for people with certain knowledge based on it. But the model exists. It exists in legislation now. So all I'm saying, take those legislation, look and see what you want. Because you have to decide what you want and then bring it back to us.
Yeah, Chair, it's a quick one too.
Member Skeffrey, I'll go to Longmore before.
Okay, my apologies.
Thank you, Chair. Thank you, Member Skeffrey. I appreciate the need for the approach that Member Brown is suggesting. But I also am glad that we are engaged in this process because we're able to also highlight some key issues relevant to especially this population to make sure that it is also considered when drafting such a committee and what is. I appreciate Mrs. Aldridge's suggestions, many of them that are very practical and useful. But again, so previously when I even mentioned about the need for the health representative, the medical representative, I had assumed that a lawyer was already an established one because that is usually what obtains. So to hear that, and I so agree with Mr. Simmons that that skill set should also be represented. So if we expand to 5 to 7 or whatever the case may be, I would imagine that those two elemental applications and of course occupational health is represented and knowledge, direct knowledge, that will make the function much more efficient. There will be less need for external involvement. You would know exactly what level of external involvement is required. I also appreciate the fact that the offer for an in-person that was always established, because we don't want the situation where just by paper resolution persons can actually abuse the system and manipulate the system against someone who maybe needs something that is directly an in-person appearance. So I appreciate that that is there and such. Thanks.
I just want to add one other point. The LRID, for example, has within the IDT the ability to use assessors. So the IDT may be challenged with a major financial thing, and it may want to use an assessor, for example, to look at a financial statement. It is allowed. And that what they do is advise the tribunal, but not vote. So all of that exists in legislation now. So we just need to pick them out and work it. So that's, I just wanted to bring.
Member Skipper.
Just a quick one, Chair. Based on the document before us, I know we have made some proposal that may have some changes, but let's say it's a 3-member panel or committee. So what is the quorum? Is it that all members must sit for is that what we're proposing? And I remember a couple of weeks ago in the Senate when we passed the data protection, they have a panel of 5, but they say 1 could sit and have a quorum. I had an objection to that, but it said that's protocol. So in this context, and we're speaking about probably an expansion. Yeah, man, he remembered, man. Angie remembered well. Yeah, man, and he justified it, Soljet. So is it so? I'm just talking about consistency. I remember that clearly. 5 members and 1 could form the quorum. The data protection bill, and in my presentation, I raised that as an issue that I have, and I was said, Senator, that's the norm. It happens in many areas. That's what was said. Not that. And I found it 6, 7. So a quorum must be involved in that context. And as we extend, we talk about the lawyer and the doctor here, the engineer asking, what about me also?
Yes, Member Cuthbert.
Am I not understanding when I'm reading over and representing the workers, and then the committee may co-opt persons who possess the requisite experience in any matter? Does that mean persons of the 3 panel, those 3 persons must then have some sort of an experience in any matter that's been heard? And how do we make sure that, is that a consistent 3-member panel, or you're co-opting persons on different matters? When different matters arise, then you're co-opting persons with that particular experience. I'm not really understanding, so I need an explanation on that, please. Because if it's a 3-member panel, is it a consistent 3-member panel? Or is it a panel with a number of persons that we then can co-opt from whenever it's needed?
Yeah, Soljan, you wanted to make a point?
I'm thinking, Chairman, it's 12:20 and 11 seconds. And my suggestion is for us to move ahead, give the ministry some time to work with us on a revised document, and then come back to the committee.
Very well, yes.
Okay?
Yes.
If-
Yes.
A little suggestion.
Yes, I'll hear from the ministry and we will, yes. Yes, Mrs. Benny.
Yes, Minister, we will speak some more with the drafter because the co-op provisions, well, it would have been a 3-person panel, but then they could co-opt. We did see this provision in the Fisheries Act and also the act we looked at with the co-opting. So we have to look more so that if you don't have the expertise there, it's in the schedule, in the appeals tribunal there. So I have seen it in 2 legislation, and so we just thought that it would have been a useful provision, especially if you had that 3-person panel. But we were trying not to draft the whole provision, but I think based on the feedback from the committee, they would like the details that we have in our heads, which we have not put in the paper, in that we were trying not to draft the entire provision.
There are reason, Chairman, that the Ministry of Labour didn't consider one of the legislation that's already existing in the Ministry of Labour that deals with tribunals or appeal. Is there a reason why you all ignore the one that you have and are supposed to be so familiar with?
We did not ignore it. That is why we went to the tripartite, because none of the bodies did that. But we didn't realize that this is decisions of the authority. It's not exactly the same creature. So while we look and see that some provisions are relevant, this is the review of decisions of the authority and appeal decisions of the authority. So I can't lift everything from the tribunal that is hearing other matters there. But we agree to look to see the provisions that are applicable, but all of it could not be lifted for this provision.
Chairman,
Yes.
it's not just IR matters. It's the natural justice principles that the Sultan spoke about that we're pointing them to in their own legislation. Those natural justice principles abide and will affirm natural justice principles. And I mean it, Sultan, when I am for alternate dispute resolution, which is where they're going. But just give us a sense of how much we have. And are the rules different? Because where I sit on a Friday, I see some of the same rules applying across the board, except sometimes we see a little shift here and there. But we already have it, you know.
Yes.
I mean, just as my friends found the bicycle, what's called the Bicycle Licensing Act? Yeah, I don't know, Chairman, let me just say this. I don't know if you know the story that Norman Manley abolished the licensing fees. It was tuppence. No, it was tuppence to license a bicycle. And Bustamante, the wise genius he was from the street, said, because I'm foolish. If it was me, I would have cut it down to farden. Not because I want to farden, but every time they go to pay it, they would remember that I cut it from tuppence to farden. But when they cut it out, nobody going to pay, and nobody will remember the good that was done. But that's just wise street politics.
All right, I think the...
Sorry, Chair?
Yeah, okay, Mr. Basco.
I just wanted to clarify a point regarding, but Member Skeffrey isn't here, about the data protection. The clause that was being examined at the time was giving the parties an opportunity to agree that one person could sit and preside. And what we said was that we didn't think at the time that natural justice would have been abridged if both parties agreed that one person could sit and hear the matter.
Very well.
For behalf, I accept.
Yeah. You're one and the same. Yes. Yeah.
And just
yes.
on the point of the plethora of appeals tribunals, the issue has come up before and it has been discussed at different joint select committee meetings. In fact, it was discussed at the data protection when the suggestion was to have the same appeal tribunal that will hear the access to information matters also hear the data protection matters, because of the number of appeals tribunals that we have, the cost to the country, and a number of other related issues. For instance, finding different persons to sit on all these different committees. Because remember, even if you give them some sort of honorarium, it's basically a voluntary task, and it can be also very time consuming. So it is something that the government has been looking at, and from time to time recommendations are made to try and see if you can use another body to assist. The problem with this law is that it may not be so possible. It may not be possible to have an existing committee also deal with like the review matters that we're dealing with here. And I suspect this is part of the reason the ministry would have been thinking of having, I think it was a part of the IDT look at some of the other matters. This discussion also came up even with sexual harassment. At one point, it was thought that there would have been a tribunal and that would have been a part of the IDT, again, because of the whole thing of trying to save costs, trying to deal with all these, trying to find all these different persons who can fill these roles. But in the end, again, because sometimes you have to consider the very specific work that is being undertaken in pursuance of a new piece of legislation and the effect and what you want to achieve. So it's a number of issues why we now have so many different bodies being created under so many different laws.
Notice you left out the one that Dr. Sophia Langmore and Senator Gale sits on, that most current Giant Select Committee, that is not the USH committee, where they're also agreeing to some tribunal too. I'm trying to remember the name of it. You can remind me the name that sits on a Thursday?
Member Gill.
You know, I wasn't going there, so.
Yeah.
But one of the things that is always, when I look at all these legislations that proposes tribunals and understanding the challenge that the IDT would have had in terms of just the administrative support alone and the capacity that is needed. And I ask myself the question whether these plethora of tribunals, if they work efficiently, and to what extent they require support. And has there been a thought whether you look at those that are homogeneous in nature and have some sort of a creation of a greater body that deals with those particular issues, rather than having a number of tribunals established, and you can't even find persons to sit, the time in which they sit. Because remember, you know, this is not in these tribunals, it's not like the IDT that has a structure of persons committed by way of employment. This is asking for you to commit service. And for those who have to appear before them who feels aggrieved, whether or not justice is being served in the manner in which they are being contemplated today. But I'm not asking Solgen for you to commit yourself in terms of a response. I'm just putting it out there for a thought.
I just have one response. I think I regret using the word plethora.
Yes. All right.
Well, let me state that my use of that word was never based on your use. I also contemplate the use of it because of my own thinking.
No, Solgen, I understand, but the reality is that there's a plethora of these. So withdraw the word and let me and Kavan use it. But there's a plethora of tribunals, and the country needs one day. There's a mental health tribunal, I'm sure there is too. There's probably a public health one. There's just a whole heap, and we have to ask ourselves, just as well, the 180 companies, state-owned companies, whether or not we have as much tribunals.
Yes. And a lot of them don't get to function because of the level of administrative staff that is required, etc., too.
Yes,
Chair, I do agree with Members Gale and underscored by Member Brown about the level of the amount of review boards and processes and tribunals, etc., But I go back to, I'm sorry, I'm the repeated voice because I hear the repeated need. A lot of what we are also relating to in these varied tribunals relate to public health. Occupation and health is public health. It falls under the ambits there. And there are a lot of committees, tribunals within that arm that this could also fall under. So I'm just throwing it out there to explore that legislation. I was just reviewing it and I see where the constituents of the Central Health Committee here that maybe you could have that expanded, which is the Chief Medical Officer and the Director of Veterinary Services. When this was drafted, this was primarily around the health that as perceived then in terms of human disease and zoonoses and animal diseases, right? But we're recognizing that health is much more broad-based than that and much more impacting and can be represented in legislation more. So that also, and expansion of that could encompass a lot of these other tribunals elsewhere. Just putting that there.
Well, there's no doubt that the committee being contemplated by the ministry in this legislation is necessary. The comments from the members have indicated that there is further work for the ministry to do in terms of this part of the legislation. And with the guidance of the Solgen, the ministry has indicated that further discussion is relevant in terms of Part 12. So the ministry will have to revert to this committee in respect of the way forward surrounding Part 12. But it is clear that a committee of this nature is necessary having regards to the scheme of the bill. What it means is that we now should move on to Part 13. I gather that from the ministry that their members, this is important, that in respect of Part 13, I gather that the ministry, you'll need to have discussions with the legal teams. But I know we are not ready to do Part 13 today. Let me hear from your ministry, Mrs. Benicama. Yes, fixed penalties. Or whether we can proceed. Yes. Ministry, let me hear from you. Yes.
It struck me, Chairman, that
Yes.
Part 13, fixed penalty and all of these clauses is subject to all the amendments and they come back to us. And so for us to go through all of these clauses, 13, 7, 38, 7, etc., etc., we need to know what those are going to look like. And in fact, those may not be the number anymore.
Yeah. But I think it is a little more than the specific clause, member. The substance of what is contained in the part. Soldier? Yes.
Yeah, we are prepared to go through clause 203. Mr. Basco had a few comments on it, not many, because 203, it's a standard provision, but we did notice one or two little things that we could just draw the committee's attention to. Yes, in terms of the sections, all of that has to be square bracketed right now, because in 203.1, the specified sections, all of that has to be square bracketed. The bill is going to change. So even if we weren't amending, deleting other provisions, because we're going to now be putting in the establishment of the body corporate at the beginning of the bill, it's going to change. So all of these sections should be in square brackets. But I mean, other than that, the chambers is prepared to go ahead.
All right, Ministry.
Yes. We were prepared to go ahead also.
Okay.
We didn't have a official paper for it.
But we can proceed.
But we had just a few.
So please do.
Hold on. All right, so we agree. May I continue? Yes. What happened is that where it lists all the sections, we thought it could have been changed to basically listing the schedule. So the clause should be amended to specify that the authority may serve on a person who has committed an offense specified in the 8th schedule, a notice in writing in the prescribed form, or when the opposite.
Sorry, where are you exactly?
Oh, wait, sorry.
'Cause you're reading from a document that we don't have.
What happens is that we don't have an official document. We just had a few amendments that we wanted to propose. We did not have many issues with this clause. But bearing in mind that many of the provisions, some of them no longer exist in the bill. So we, as the Solicitor General said, but in terms of the general principles set out in 203 to 204, that is what we would be wanting to discuss.
Okay, so you're starting at 203.
I was suggesting, though, an amendment to 203.1. That is what I was trying to read out here.
All right, proceed.
I'm going to do it slowly since you don't have
Very slowly.
This clause should be amended to specify that the authority may serve on a person who has committed an offense specified in the 8th schedule, a notice in writing in the prescribed form, offering the opportunity to discharge any liability on conviction of that offense by payment of a fixed penalty as specified in the 8th schedule. So instead of listing on the face of the bill all the relevant sections, we thought you could have referred to the schedule itself that also has the provisions listed there. But that is more drafting, so it's a recommendation of the ministry.
Just to be clear, Chair.
Yes.
A fixed penalty and a conviction. A conviction leading to a fixed penalty, or the concept of a fixed penalty for some violation, which have nothing to do with a conviction. Sorry?
The payment of a fixed penalty is before, and it's what it's doing is giving you an option to discharge, so they wouldn't go to court.
I agree. Just that.
It's just a wording. It's just wording.
That's what I'm talking
Yes,
about.
it's
Can't be a
wording.
conviction.
No, it wouldn't have been a conviction because then the fixed penalty would not operate.
Question of the fixed penalty. So the fixed penalty really depends on the magnitude of the transgression?
Well, it should, because we have said in other laws, for instance, depending on the type of offense, there are some things that should not be easily discharged by just paying a fine. However, in laws where you have regulatory breaches, so under the Betting, Gaming, Lotteries Act, I mean, everybody knows road traffic, but like BGLC, you can, for certain offenses, and they do have a big regime for offenses where they offer the offender, the alleged offender, the opportunity to discharge liability on conviction by paying this fee, and it's used to help to encourage compliance to an extent, and also it's recognized that you don't want to clog the courts with a number of matters, and especially when you're dealing with a body corporate. Even if you went to court, you don't send a body corporate to prison. I mean, you could technically send the directors to prison, but generally these are offenses where you're penalizing generally the body corporate. So here, really, your PCBU, to me, would be your bigger offender that you would be targeting with this fixed penalty regime. So I think when the bill is at such a stage, the committee will have to look through to determine, as it did, I think, we had to do that for road traffic offenses, which offenses you can discharge by way of a fixed penalty regime and which really you should go to court, because there are some things you should go to court about. Just depending on the nature of the matter, depending on whether you have to have a certain sort of judicial determination on a matter, or to send a signal to the community that something. So on the road traffic, dangerous driving, you can't discharge by way of a ticket. Where you have to have one, judicial determination, two, you also want to send a signal to the community. But there are some regulatory matters that you would allow the offender. Now, there is also now 2 ways that the fixed penalty regime can apply. The normal, or not normal, the usual method is where the person who is going to discharge a liability is offered to pay less than the amount they would pay when they go to court. There is another concept, which was under the betting, gaming, lotteries. Because of the nature of those regulatory breaches, it was flipped. So the alleged offender pays, I think it's double or triple what the court would, what you would pay if you went to court. But the persons who are targeted under that would still prefer to pay the penalty rather than go to court on some of these matters. So I'm just saying there are two ways for it to work that the committee can also consider to see what is applicable or what would be more suitable in this situation as well.
Mrs. Seeley Brown, you had a comment?
Yes, where that is concerned, you don't want to have a situation where a business with its awesome ability to pay their way out of certain offenses rather than facing the penalty of appearing before a court. And you have some who, because they can afford to pay their way out from the start. So we and also repeat. So it's something that we really, as a committee, may have to examine thoroughly before we make a decision.
Yeah, but Senator Gill, it works the other way too. Because I am rich and I can afford lawyers, and the next trial date is 2025, as the chocolate said, right? 2025. It suits me to just sit back and say, all right, see you in court. Whereas a conscientious employer may choose to, that's the GG, may choose to resolve the matter and move on and get rid of the nuisance if they think it's a nuisance. But again, I accept all the Sulgency. I explained before that in Louisiana, I found visiting the Gramercy plant that their regime had fixed penalties. First offense, 1x. Second offense, 2x. Third offense, 3x. So that the fixed penalty can also have variation. So it punishes somebody who knowingly does wrong or know that what is done is wrong.
Minister?
Yes, Minister. And we would like to point out, though, because I know we're not looking at the schedule, but we're already concerned that some of the offenses should probably not be included here that we're looking back at. So you have failure to comply with an improvement notice, failure to comply with a prohibition notice, failure to comply with a non-disturbance notice, failure to comply with obligations for secrecy. So in terms of what actually exists in the bill, we're also looking to see is it appropriate, because we really mean it to be for certain minor offenses. So we are also examining each offense, and those are the ones that we would flag immediately that probably should not have been included in a fixed penalty provision.
Okay. Yes, sorry.
I'm just going to ask Mr. Basco, there are a couple other little things on 203 that we could just point out now and just address at least.
Yes. Mr. Basco?
Yes, Chair. We were also suggesting that in clause 203, a provision should be inserted which provides for the fixed penalty notice to operate as a summons.
That is if you do not pay within a certain time? Okay. Very well. Members?
Fair enough.
Minister?
We have no objection We'd like to bring the committee just to 2032 because there's a timeline in there. We would like the committee just to look at this provision in the bill.
You're aware. 2032?
Yes.
Yes. Members, could you direct your attention to clause 203?
A person
203 subsection 2. Yes.
A person shall not be liable to be convicted of contravening a provision to which subsection 1 relates if the fixed penalty is paid in accordance with this section and the requirement in respect of which the offense was committed is complied with before the expiration of 14 days following the date of the notice referred to in subsection 1 or any longer period as may be specified in that notice. So we just ask the committee to note the timeline that has been placed there. Yeah, 14 days or such longer period.
So are you saying that there are two things that must be done? The fine be paid, as in the fixed penalty be paid, and that the breach is rectified within a certain time.
There's another element to it. It's paying off the fine and also rectifying, remedying the situation.
Very well. Yes. Legal team, is that sufficient? Yes. All right, while the discussion continues, Member Gill, Member Brown, I will
just to clarify. I believe in the scheme of the legislation, there need to be set out some on the fixed penalty, that regime on fixed penalty, and then the rest flows from that. I'm not sure that is very clear in this legislation. And what's the rationale for 14 days as against 30 days? Because you asked us to look at the days, but I don't know why 14.
Yes, Mrs. Seeley Brown.
I just have a little issue because of the nature of what we're dealing with. So I am fine with the provision up to where it speaks to the penalty being paid. But when it comes to the time period now, the 14 days, I don't know if we can have a blanket period for compliance with whatever requirement you may be, in addition to the penalty, you may be expected to do something more. And I think in some cases it may require a bit more time. I don't know if we can, I was thinking of leaving it wide, but we can't because it's not a court. It's not an order of the court. So we have to think of how we're going to fix, how you comply with the undertaking within, the time period.
So the suggestion is that the 14-day period may be too short to rectify some situations.
Yes.
You remember last week I raised the concern in regarding the possible importation of materials that may be caused to remedy. And so if we have in this case 14 days, well, everybody talking except what I wanted to clarify,
yes,
what I wanted to clarify, Mrs. Bennett Campbell, is that this part that speaks to or any longer period as may be specified, does it take into consideration that 14 days may not be enough? So by some appeal made by the person conducting business, there may be an extension of the notice?
It recognizes the fact that in all cases, 14 days may not be sufficient for you to actually pay the penalty is one thing, but actually rectify the situation based on the nature. So it was giving more latitude in that particular case. But I have noted that some legislation start with even 30 days and then go up.
Mrs. Seeley Brown, you have a problem with the or any other longer period as may be specified in that notice? Would that satisfy the concern you highlighted earlier?
Yes.
Yes.
What we're trying to achieve here, the payment of the penalty or the rectifying of the situation?
Both, it appears. It is about, but for me, there are two things there: the payment of a penalty and the rectification of the breach. There are two issues there. That's why I want to.
But
I want to hear from the legal team if it is good as it is.
While they come in, but the 14 days
Yes.
is to pay within that time frame to pay the penalty.
Is that what it is saying?
No, that's what I want clarification. So what is the 14 days for?
It appears to be, my understanding is that it is to rectify, it's both, actually.
No.
Chair, if me rectify the situation, why must I pay a penalty?
Which is why I wanted to hear from the legal team. Yes.
And the thing is, I'm trying to figure out where this provision, I've seen it in another law. You see, this is a problem when we take something, we copy and paste. It's not, this is in a few other laws, but it's not in every law. So with road traffic, for instance, it's just a strict liability.
Yeah, exactly.
You don't have your driver's license, they give you a ticket. You pay. Whether or not you have complied, it doesn't matter if you have complied within 14 days. It's just that, or you change your pants, and you left your wallet at home. The point is, you didn't do something, you've been issued a ticket, you have the opportunity to discharge it or go to court. That's usually the basic rubric. Now, this other component crept in, and I'm going to try and figure out which law did it, because it may have been done for a specific reason to have enforcement or compliance with something. The problem is when you twin it, I'm now not sure what it would mean. If you comply, then does it mean that you don't pay the ticket?
I think my understanding is that the moment the ticket is issued, you are, yes, and you are bound to pay. What I think we may need to say is that so long as the breach exists, then you are exposed of being issued with a further ticket.
What this is contemplating, is if I commit a breach, I have to pay, but I have to comply. I have to fix it, right? And we're saying whether or not you need the two. There are some legislations that once exposed, once you breach, you're going to pay a penalty.
Strict.
It's strict.
Yes.
The determination is whether or not all the acts of transgressions would cause that in the first instance. With a double-edged, because in my mind, this is a double-edged sword.
What we do, Chair? What we do, Chair?
Yes.
But what we would do then, Chair, is when we are picking out the offences that we are going to make fixed penalty offences, we ensure that they are strict liability offences. So there's no need to guess. Yes.
For rectification.
Yeah.
Because once you have breached, you are duty bound to rectify.
Yes. And other provision should tell you that you should not breach in the first place. But you don't need to tie a boat. Because if I'm traveling, for example, on the road, and my headlamp is out, and I get a ticket, if I continue along my journey, I can get 10 tickets before I reach home. So I should stop and fix it before.
That's the point. All right. Member Daly, welcome.
Thank you. Sorry to be late, but I was determined to be here today. Like other places, other joint select committees, I am a very practical person, and I do not wish to participate in passing laws that are difficult to enforce. That's a premise I start with at all times, because we have so many laws. Environmental wardens, we have this, we have that, and people still go into the public square and do as they feel like. So let me put this to the learned councils, including yourself. I operate an establishment. Business, well, it's already defined in the law. The OSHA officer visits my establishment and observes a breach. is that the owner slash operator, whatever, of the business is automatically, and I'm going to use the term, ticketed for that breach, or the OSHA officer will say, I have observed a breach and you have to have it corrected. I want to know what is it we want to get. When you, remember, you know, and I keep, at the first meeting we had, I said, every single wholesale downtown Chinaman shop, every single, and I'm not in any derogatory way, please, because the majority of the wholesales down there will be covered under the OSHA bill, will be covered under this OSHA legislation. Every shop in Anchovy, every store, every enterprise where business is conducted and customers come will be covered for safety under this. And COVID has exposed a lot of shortcomings in many business places. Ask the question again. When the minister, when the entity, the authority sends out the OSHA officer and he observes that the crane is too high or is not properly positioned, is it that you're going to issue corrective instructions to that construction company immediately and say within the next 24 hours the crane must be properly positioned, or you're going to ticket the person? What is it that person commits at that moment when the breach is observed? Let us be practical now and see if we can answer that in practical terms. Please, Chairman, if I so indulge.
Certainly, the objective of the bill is to ensure compliance, but Mrs. Bennett Campbell will answer. Yes.
Chair, whilst we wait, I'm not too sure if I'm clear what the final consensus was regarding what Member Gale had brought up, re the fixed penalty situation. I'm not sure if
the discussions are still ongoing.
Right. Okay.
Yes.
Right. No. Yes, I recognize that, but it has evolved. But with respect to, all right, let me hear, Ms. Bennett Campbell until.
Mr. Mahan.
Good afternoon. Member Daly, the purpose of this fixed penalty is to discharge the liability for minor breaches. So if you look at the age schedule, we mentioned before you came that we need to look back on them because some of them should not have been included in the schedule because they're not minor offenses. But if you look in the age schedule, like failure to keep a record of each notifiable incident for at least 6 years, that's a minor offense in our estimation. It is a requirement, but it is a minor offense. So these are the type of offenses. So the example you gave about having a crane in a dangerous position, right? We would issue a prohibition notice, and that would not fall under the fixed penalty regime that we have here. So it's really for minor offenses.
May I suggest that at some point in time we revisit all the fixed penalties?
Yes, and as
are presented here.
Yes, and we said that we will.
Okay.
Yes, Member Long.
Yes, I'm now back on track with respect to what Senator Gale, with respect to your response. So, the matter of a double penalty, if it's a matter of a fee and also correcting the situation. But it goes back to the offenses being based possibly on a tier system, which is what I'm now in, minor offenses versus. But recognize that can be, there's a cost associated with the administration by the ministry to enforce and by the enforcement of persons who breach these things. If you don't have a penalty associated, it could become a matter of habit, and you have to send that public message too. So whether it doesn't have to be an exorbitant fee, but a penalty, but again, probably based also on the tier system of the level of offense. So for that tier 1 offense, it's a $10,000, well, going up to maybe $200,000. But Member Daly, we also were just discussing regarding the penalties overall for civil offences, etc., and such. And in another place, clearly that is also topical. But the recognition that there is a limit of 7 years or a cap of 7 years that tends to exist there. So is it then that we want to fully extend that? I know that that discussion is going on in terms of the penalties around civil. But to say that this can exist at not the review process, but at least that liability is there.
Yes, I want to hear from Mrs. Celia Brown. Then, yes.
Add to what Mr. Mahon was saying, though, having issued that compliance notice or whatever notice, that person still does not comply, that offense in itself can be a fixed penalty, could be one of the penalties within your regimes. So you understand the point I'm making? So you go in and there's non-compliance, you issue this notice and that person still doesn't comply. Then you're going to penalize that person for non-compliance, and that actual offense can be an offense within our fixed penalty regime. Maybe not all of them, but some of them maybe. Yes.
All right, I'll hear Member Daly before I go to Skeffrey. I've been here. Yes.
I'm glad that point has been made by Mr. Brown. No. The Senate, okay. My objective is always to protect the health and safety of the workers at the workplace. My objective has been and is to protect the customers who come into that establishment. So therefore, if I go into a shop downtown and there's a slippery floor, and customers have fallen from that slippery floor on many occasions, somebody makes a call to the authority. The OSHA officer goes to visit Mr. Brown. Observe that the proper floor is not laid. Gives Mr. Brown time to correct that because several persons have suffered injury in that store. Is it that Mr. Brown is given a time frame to correct the breach, the health and safety breach, or Mr. Brown is immediately given a ticket, and I use a ticket in the casual sense, given a ticket for having that breach?
Yes. Mr. Mahon.
So what would happen in a circumstance like that is that the officer would have done the assessment, and then we would have issued what we call the improvement notice. So the improvement notice functions as to give a time frame within which for it to be fixed. As well, it serves almost like a warning because it is citing that this is a situation that exists and you need to remedy it within the time that is set out in that notice. So it's not an automatic ticket as how we would have probably looked at under the road traffic where you get a ticket and you should go and pay monies immediately. It is really giving you a warning to say that this is a safety and health problem. This is a time frame within which it must be fixed. And then it will also in that notice have directions as to what should be done to fix it. Yes, that is where you will now probably move.
That which the OSHA officer has identified and given the written notice to correct, however. Let us take, for example, which of the fixed, which we're going to come to. Let us take air quality. Let us take air quality, which we in COVID, so many things have come to our knowledge. We have become a much more health and safety environment. Let us say you go into an establishment with 500 workers. Workers are getting sick over and over, and the OSHA officers have done all their investigation, health and safety officers go in and thing, and the problem is the air quality, because the ACs have not been serviced and so on and so forth and whatever. You have a 10,000 square foot establishment with 300-400 workers. It's not easy to correct the air quality in 24 hours. Not easy. Businessman, not easy. You either order a shutdown order of the establishment and put some people out of work, or you give time to have it corrected. I would like this committee to be mindful of issues like these. There are some things that can be corrected immediately, and there are some things, some health and safety breaches that cannot be corrected instantaneously.
Yes, Mrs. Seeley Brown.
I agree. And just to add that also, agree
to
what Member Daly was saying, that it depends. But for us to also remember that it's not every single offense is going to be tied to to an improvement or a compliance notice. And in those cases, for instance, I'm looking at one of the offenses that's now attached, that has a fixed penalty attached to it, clause 127 under the bill, which deals with the offense of hindering or obstructing a labor officer in carrying out his duties. So that would be a straight fixed penalty. There would be no need for any. You understand? So it depends on the circumstances of the case. So when we go.
I question, why is that a fixed penalty? That should not be a fixed penalty offense. That is not usually a fixed penalty offense. That's very serious.
I'm with you.
That's very serious, and nobody should get that opportunity to just pay money because I hindered.
Yes.
I'll pay the money today, and tomorrow I'll hinder again, and you just issue another ticket, and the cycle goes on. That should not be a fixed penalty offense.
I know that's something the ministry is looking at.
We have to, yeah.
I know
think
that's one
when
of
we're
the-
going through,
yes.
we'll check and ensure that we.
Yes.
Chairman,
Yes.
Member Daly
Yes.
raised something a while ago, and something else just jumped out at me. So you issue a prohibition order that may stop the place from conducting business. The fault is not the cause of the worker, but the worker would stop working, and the question of payment to the worker. In this case, the employer who is at fault would have to treat with that situation, because hearing now, they may want to propose, and Member Brown, this question of layoff today, and where some employers are seeking to promote or encourage an extension of a layoff period that we're not necessarily in support of. But in this case, because of the possible prohibition order that may suspend work, you may have situations where workers, an employer might want to suggest, well, I can't pay you because no work is taking place. And I know the legislation never sought to address that, but there's a likelihood of that happening.
Safety and health bill, you know.
Sorry?
I said the legislation is primarily considering safety and health matters.
Yeah, man.
And I do not know if this legislation
No,
could.
and I am saying, Chair, that these are the issues that we might have to deal with on maybe another legislation.
Within the same ministry.
But legislations are always compatible of each other, or dependent on each other. But I just want to put that out there.
Very well, Member
Because
Jones.
If
Dr. Robinson is here, you know.
Yes, he's about to speak after Member Daly.
If you'll allow me to just
Yes.
pick up on where Senator Gale has put it, it goes further than the employer. The employer, where that breach is occurring, might be a tenant who the owner of the building with those 300 workers failed to fix that breach. It's not easy, you know. And COVID has opened our minds. The Ulrika place said that they rent the place and they superseded the standard established by the Ministry of Health, if you recall, in their one-page Weekend Gleaner ad. They said they superseded thing. And they are tenants. So any fault of that breach, Senator Gale, the same employer who is Senator Gale and Company, but rented the building from Senator Brown. And you have complained to Senator Brown over and over to fix the breach. And he has not done so. Should the worker suffer? That's the point, and I think no, but that is not for this legislation.
Yes.
Should the employer suffer too? Yes.
Chairman.
Because the owner of the building that failed to correct the breach. But that is really taking us into another level. Another
laws.
level.
Yes, I will hear from Dr. Robinson, then I come to you, Member Amor. You had a comment?
Thank you, Chair. So just a few comments I'd like to make. Nothing opposing Senator Cavan in any way. But what I'd like to say is that if we're looking at this bill from the standpoint of...
Sorry, Chair, I'm unfamiliar with Dr. Robinson. What is the context in which he's...
I'm representing PBCJ.
Oh, okay, thank you.
Oh, you came a little late.
No, being a doctor, you may think he's a medical doctor.
That's why I wanted to make sure I clarify what is the context.
It's doctor by description, not prescription. I certainly go to jail for that, yes. Yeah. So what I was wondering is if, upon visiting a site, the OSHA officer, if we are looking at employee safety first, because that's what this is all about, and upon assessment, the OSHA officer recognized that there's some amount of breach, which may not be blatant at all. I can understand why, in that regard, a non-conformance could be drawn, and then from that standpoint, time frame or timeline be given for corrective action. The flip side of that is where there's a blatant disregard for employees' health and safety. And I'm wondering if at that point the OSHA officer has the authority to probably close an operation, because if the danger is imminent, then given a time frame to fix a particular situation, you may just be a day too late, just for consideration. So the focus should really be on mitigating rather than probably on payment. Just for you to consider. And from Cavan's standpoint, let me just answer that question. The truth is, you do have some employers who are very small. They don't have the expertise to guide them, so to speak, to put in the necessary things that they need to put in place to protect the worker. And so sometimes the breaches are there because of ignorance. That's one. And secondly, if they are in a blatant breach and let's say the operation closes, they may have a challenge coming up with funding to fix and to be paying at the same time. So I don't know if you want to categorize that kind of thing, but I think particularly when you write a bill and it's for everybody, then it may be at a disadvantage to small employers. Just a point.
I was only suggesting that these are circumstances that will arise, and so it's best to prevent. But the other thing, there are going to be some breaches that we must just outrightly state must not be committed. and if we can identify those in the first instance, that you're not going to take, you're going to just create state prohibition orders instantly. And you are in breach because these are known, established, that are more egregious in nature.
Chairman.
Sure.
Sorry, go ahead. Sorry.
Yes, Member Longmore.
So, again, just kind of going back to reviewing the how this references to public health for me. And in terms of, I'm looking at the Public Health Act, Clause 3, 4, 5, the Central Health Committee, and it is established to advise the minister and the local board on such matters connected with the public health as they see fit, and on any aspect that's subject referred to them by the minister of local board. The local board.
Member Longmore, I'm just trying to understand
how
if
it
you're
relates.
taking us back
Yes,
or we are...
what I'm trying to, okay, so it is a response to multiple issues with respect to what
Could
we're
I just
discussing,
ask-
and Mr.
So
Mahmoud.
could I just ask you to yield on since we're on penalties?
Yes.
Right,
Fixed
but
penalty.
what I'm trying to get at is the reflection that there is almost an established system already that exists in law regarding penalties and the consequences of breaches of it based on the public health infringements. So you already have listed, right, overcrowding in buildings, etc., provision, maintain a public sanitary cleaning, this, you have those, but what we also need to see is an expansion of that to include worker safety.
Yes, but these penalties arise from the provisions of this act.
Yes, but in terms of a review process and the penalties, it is reflective in the public health damage. So what I'm wondering is, in terms of coming up with a new tribunal, in terms of coming with a new administrative structure to resolve the issues in occupational health, we probably have an existing structure on the public health. That all just needs to be expanded. That's my point. And in terms of penalties, the guidance for penalties is the level, the numbers of persons exposed, and the personal exposure to each individual to the level of extent of that exposure. So that is already a consideration. So that's my point to say with respect to penalties, the tribunal, there might be pre-existing structures to handle such.
All right, Member Brown, you'll make the final comment on this point. It's
I understand my
19
colleague
minutes.
to be saying we need to
Yes.
synchronize the two bills, the two laws. But my point, and I'll raise it now, or we can come back later, is...
After lunch.
Yeah, I am not seeing, and I might be mistaken, continuing offenses. In other words, that there may be offenses that are continuing. And I know in other legislation, for example, if the tribunal order me back to work and I refuse to go back, there is a penalty for each day.
That's the
or
point.
for the employer. So in this bill, where somebody is in violation, is there a provision which says for each day that you continue in violation, not necessarily a fixed penalty, but I am not sensing it in the bill, and there ought to be such a provision.
When
for
the
continuing
sergeant
offense.
commented, I gather that is what you're saying, that for each day a breach continues. If it is that you're using the ticketing system, the moment you get a ticket, it is expected that forthwith you're going to rectify the situation. And for each day that breach continues, you're exposed.
So my question is,
yes,
in the legislation we're drafting,
yes,
is there such a provision? Because I believe there ought to be such a provision.
My understanding is yes, we come.
Member Brown might be alluding to is the penalty would be progressing because each day you are continuously in breach. So is there an increase on that penalty?
So it's a progressive increase.
Right.
Okay. Very
So
well.
you would know, Senator, I like that Senator Gill has adopted the progressive approach.
Yes.
But progressive or otherwise, what I want is a penalty for continuing breach. It may go, I will be with him on the progressive nature of that penalty, but there ought to be something for continuing offenses. That's what I said earlier. Not fixed penalty.
Okay.
Although we could get it there. But for me, the issue really is, the issue is that there must be a punishment in this law for continuing breach when it has been no. You're supposed to lock off X section. You don't lock it off. Tomorrow you'll keep it open. The next day you keep it open. For each day that it continues in breach of a prohibition order, for example, there must be penalty for them.
Any comments from the legal teams? Sergeant, yes?
Yeah, I was just saying, so you can have certain offenses that you can have a penalty that says if they go to court, on a first offense that they're found guilty is $100. If there's a second offense, it's $300. A third and subsequent offense would be $500. So it would mean that the court would have to be told of the antecedents.
Where I'm going is simple this. You're given a prohibition order. As of the 15th of March, you must shut. But you continue to breach it. I'm saying for each day that you breach it.
Right. That's the concept of the continuing offense. But normally, that's not even how it would operate. It would have operated where you would have been charged for breaching, for doing it on a particular day. And then we would have then this concept of the continuing breach, that's another $20 for each day. But we have not been going with, there have been some issues and challenges to that approach. So generally, we don't have that approach anymore. We have been actually amending the laws to take that out. And what we say is, every day it's a brand new offense. So every day they could give you they could charge you with a new offense. And they would give you a new ticket if it's a fixed penalty, or if not, they charge you again. So each day they charge you for a new offense.
I am comfortable with an approach like that, but there must be penalty for continuing the breach.
Yes. And in fact, that approach is actually harsher, because when it was a continuing offense, it would have been a much lower penalty. If we're now charging every day as a brand new offense, it's actually a higher penalty at the end of the day.
All right. Yes, Member Brown. Yes, I know. So, members, we will, at this convenient moment, we'll go for lunch. My understanding is that, part 13 ends at 2:08. Part 14 begins at 2:09. So today we will only be able to complete part 13. So we'll return from lunch to discuss a few sections, and then we would break for the day.
Likely, Chairman, that at the next sitting.
Yes. Well, you came for lunch. You came for lunch. You came for lunch.
Chairman, is it likely that at the next sitting?
Yes.
Not this afternoon. Sorry.
Well, let me hear from Member Brown when I come to you, Sergeant.
Sorry. So the only other provision in Part 13 is Clauses 205 to 208 that deal with offenses against the Crown, and we were going to be asking for those provisions to be deleted to 208. Yes, and the Act can simply say that the Act binds the Crown, but these sort of provisions, there are issues with them. There are issues because, first, we have now changed the scheme of the bill to a body corporate. The authority will now be a body corporate. It will no longer be a department of government. We also have to contend with the provisions of the Crown Proceedings Act. Because we have changed the scheme, the Attorney General wouldn't be the one doing the application because it's a body corporate. They actually, remember, they can sue and be sued, the authority. The Attorney General, by virtue of the Crown Proceedings Act, we only represent the Crown, central government, really. There are times when we may be asked to also assist. Well, executive agencies are still considered central government. There are times when we do assist other government companies and statutory bodies that don't generate their own income and are on the public purse. But we would not have been making applications on behalf of this authority. So that's the first thing. And then there are some other issues, again, some inconsistencies with, so there is case law about civil proceedings compared to criminal proceedings. You don't say that the Crown has committed a criminal offense. And if the Crown commits a criminal offense, what's the sanction? Who do you apply that sanction to? These are very tricky. These are tricky issues that, again, we would not support some of these clauses for all these different
Problem with
reasons.
205, where the Attorney General must take action against the Crown.
Chairman, what we were saying is, if we break for lunch, we'd be coming back just to say delete the rest of the clauses.
Once every...
And if I may be so bold to speak for the ministry, I don't think the ministry is going to oppose our submissions in relation to clauses 205 to clauses 208.
Mrs. Aldred.
I want to hear from the members.
Mrs. Aldred and Mrs. Brown and the team. On my way down, I was reflecting on the monumental task that both of your agencies have with all of these joint select committees. I know, and legal reform, I said all of them. And I actually said to myself, where did you find time to do the other work that you have to do? But I understand. But this kind of discussion after lunch would be a very healthy discussion and, vibrant. Once the Crown can be held liable, Chairman, once every department and agency of government is also going to be bound by the law of health and safety, that's all we want to know. Yeah.
The Act can simply say the Act binds the bill, can say the Act binds the Crown. But in terms of no criminal sanction, that's a different thing. So when we say that the Act binds the Crown, it means that the Crown is supposed to comply with the law, and you could have some civil sort of remedies, and so here.
Members, let me. So do we return for lunch, albeit for a relatively brief period? Okay, very well. So we take the lunch break now, and we will resume. Members, about what? 15? Yes. So we will resume at 15 minutes past 2, 45 minutes for lunch. So we adjourn for the lunch break. Very well.